Good afternoon, ladies and gentlemen. On behalf of CESA, I'd like to extend a warm welcome to our members and those viewers who have also joined us today for our latest best practice webinar, which follows our successful series on the newly revised CESA practice notes. This webinar is on the topic of the newly revised CESA forms of agreement. I will be your moderator for this webinar. My name is Wally Main, and I'm a civil engineer occupying the position of Contractual Affairs Manager at CESA. This webinar is the first of 4 CESA best practice webinars we are planning to present during the remainder of this year, and we hope that you will find it sufficiently interesting and useful that you'll be inclined or tempted to attend the other 3 webinars as well. It is planned to hold the webinars on the following dates, which you may wish to write down. It's the 23rd of August, 27th of September, and the 3rd of November this year. I'd like to take this opportunity to draw your attention to the annual CESA conference. It was also on the holding slide, I think, known as the CESA Indaba. It will take place on the 18th and 19th of August, 2022. It will be an in-person event at the Indaba Hotel in Fourways, Sandton, and it will be a great networking opportunity, particularly post the COVID pandemic. I would also like to inform you that the webinar is being recorded and that the presentations will be available after the webinar on the CESA website by clicking on the headings Guidelines, Presentations, CESA Forms of Agreement. To access the recording of the webinar, simply go to the CESA website, click on the YouTube icon, and scroll through the recordings. Before we get started, I'd just like to outline some of the house rules for you, our delegates or viewers. On the taskbar at the bottom of the screen, you will see the chat and the Q&A icons. Please use the chat for any comments you may have, while use the Q&A for any questions you'd like to ask, and also to kindly indicate which of the panelists you would like to answer your questions, which will be in a 15-minute or 20 minutes Q&A session at the end of the webinar. To unpack today's topic, we are fortunate to have 3 very knowledgeable panelists joining us, and for which we thank them greatly. They will each deliver their presentations, and at the end of the webinar, there will be a separate question and answer session, as previously alluded to, which will cover all the presentations. So there are not going to be questions and answers after each presentation. Thereafter, the proceedings will end with some closing remarks. And I'd just like to kindly remind the panelists to keep to their time allocations as per the program. The first panelist is Craig Clark, who will address us on the CESA Model Professional Services Agreement, May 2021, as well as he will provide us with an overview of the CESA forms of agreement in general. Craig is a professional engineer and an active member of the CESA Supply Chain Management Committee. He is a mechanical engineer with over 40 years experience in that field, and he is a CESA past president. Of note is that Craig was greatly involved in the recent development of the CESA practice notes, as well as being chiefly responsible for the revision of all 5 of the CESA forms of agreement. So at this point, I'd like to hand over to Craig. So over to you, Craig.
Hi, good afternoon, everybody, and welcome to the CESA webinar. And it's my great pleasure to present to you the suite of documents that CESA has produced and published over the last 12 months. Just to have a look at what the documents comprise, we have the Model Professional Services Agreement, and I'm going to talk a little bit more about each one later on. We have the short form of agreement, the compact form of agreement, model consultancy agreement, and the joint venture agreement. And then there's also an older document which is still very valuable and still in use and very applicable, and that is the CESA pre-bid agreement. I'm going to talk mainly about the first three documents this morning or this afternoon, and the other speakers will speak to the other documents. Just a brief history about CISA's forms of agreement. I went back in the records, and what I found is that the CISA model form of agreement, it was then the SAACE model form of agreement, was first published in about 1954. So it really goes back a long way. And that was probably 2 or 3 years after the Association of Consulting Engineers was established in South Africa. The original documents included the terms of agreement, the conditions of contract, if you want to call it that. It also included the scope of services and the terms of remuneration and the fee scales. They were all included in the one agreement published by the Association of Consulting Engineers. And then in the year 2000, when the Engineering Professions Act was published, or promulgated, sorry, the responsibility for publishing the scope of services and the fees moved across to EXA, and they were deleted at that stage from the CISA agreement documents. So the CISA form of agreement took the shape of a proper form of contract, as you will find for construction contracts and other professional service agreements. And it excluded the scope of services, or obviously in a construction contract, that would be the scope of work, and it excluded anything about remuneration, because that was part of the EXA documents. So the CISA form of agreement was actually discontinued sometime after 2004, because at that time, CISA was working very closely with other bodies like PROXA and the Construction Industry Development Board, CIDB. And it was felt that the CISA form of agreement was perhaps no longer required. However, it wasn't long before we found that popular demand amongst the members of CISA and our client bodies called for the reintroduction of our form of agreement. So that was done, and in 2014, let's call it more or less the current form of agreement was published again. Now, in the years between probably about 2008 and 2014, the other forms of agreement were developed by CISA, and that included things like a sub-consultancy agreement, a short form of agreement, and a JV agreement. Those were all developed, but because the main form of agreement was no longer in use, these other documents tended to be developed in isolation. In other words, they were not properly aligned with the model form. So they were all good documents, but they weren't aligned with the model form. And then in 2016, the late Ivor Evans undertook a really, really detailed review of the CISA form of agreement, and he made many, many comments. And sadly, he passed away before this work that he had done could be put into practice. But the legacy he left behind was, it was actually quite amazing, the detail he provided, and it gave us a solid foundation to work from. And over the years, basically 2019 to 2021, we went through the whole process of developing the new suite of documents. And indeed, over the past sort of 12 months or so, the full suite has been developed. Looking at them, just a broad overview of our CISA suite of documents. First of all, they're well tried and tested. As I said, the main form of agreement goes all the way back to 1954. It's been it's stood up to the test of time. It's been tested in many disputes, I suppose. I assume it's been tested in court, and as necessary, it's been reviewed on a regular basis. It's been amended and improved. So it really is a well-used document that one can use with confidence. And mainly, not mainly, but it's also obviously aligned with local and international best practice. Part of the review process has been to review various other local, national, and international forms of professional services agreements, and we've made sure that what's in our document meets up to best practice standards anywhere in the world. I think if I were to summarize the real essence of all the CISA forms of agreement, perhaps compared with some of the others, is that they are really simple and easy to understand. They avoid unnecessary legalese. They really meant so that a layman or somebody that's not trained in legal matters can understand them and apply them easily. And they are also, I think, intentionally kept, I won't use the word short, but shall we say brief. There was a conscious effort all the way through to avoid unnecessary excessive wording and long, complicated clauses. So they're simple and easy to apply. I may perhaps boast on behalf of CISA, but I honestly believe that many of the other professional services agreements that we see in South Africa are probably loosely based around that very old CISA form of agreement. And indeed, I probably could say that the old form of agreement was based on other documents which existed at that time back in the 1950s, both in South Africa and overseas. So it's also professional services agreements are similar in their construction, and it is just the detail of how we put them together that is different. So what have we got with this CISA form suite of documents? For the first time, I can really proudly say that CISA has a complete set of professional forms of agreement, and all of them talk to each other. They all were aligned carefully with each other, and they cover most consulting engineering services situations. And finally, I think if we can simply say that they are all ideal for South African conditions. There are obviously other forms of agreement in common use in South Africa, and that some of them, or all of them probably, are really good documents. But I think our CISA documents have something special and something extra which make them particularly suited for use on any consulting engineering services agreement. If I now look at each of the documents in isolation or on their own, they all based on what I would like to call our main model professional services agreement and specific data. That is the core document that everything else is based on. And the structure of that document, it's typical of any professional services agreement. It starts off with definitions and interpretation. It carries on and it describes first of all, the obligations of the consulting engineer, then the obligations of the client. It then looks at the duration of the agreement and the remuneration. And it then looks at the very, very important aspect of liability and insurance, which could perhaps go under the label of risk management aspects. It then covers general provisions covering general legal matters, and finally dispute resolution. And then perhaps even more important is the separate section known as the specific data and the appendices, where the client and the consulting engineer fill in details which are applicable to the particular project situation that you're working on. Okay, so that's the general structure of the document. It would take far longer than we have the time for here to go into right through the document, but just to talk briefly about some of the highlights of the 2021 form of agreement. First of all, it certainly is based on the old CISA form of agreement, and it's got all the fundamental features in that form of agreement, but it wasn't just a facelift that was carried out on this update. Really, the document was completely overhauled. So we went through it clause by clause, sentence by sentence, and made sure that everything was what we wanted it to be. Some of the more significant changes that were made in the document, and I must say the changes were not massive changes, because the old form of agreement really was a good document, but as always, there's always room for improvement. So some of the main things we looked at was to define intellectual property rights, which was then added onto the copyright clause to make that more applicable to the modern situation. Subcontracting or subcontracting work to a sub-consultant, that clause was tightened up and improved on, and subcontracting is only allowed with the specific approval of the client. Then there was a clause added to deal with the time for completion, obviously vitally important. Any contract, any construction contract has three cornerstones. They are obviously the scope of the work, the cost, and the time, the program. And that was perhaps a little bit loose in previous editions of the model form, so we tightened up on that. It was, I don't like to use the word lightly, it was perhaps fortunate that this update took place when it did, because the COVID-19 pandemic highlighted or brought to light a number of shortcomings in force majeure clauses in many contracts. And this was an opportunity to improve that wording and make sure that it covered situations such as a pandemic, which were not clearly covered in the past. And you may well remember that initially during the early days of COVID-19, there was a lot of confusion and doubt whether existing insurance policies would actually cover the situation of COVID-19. So that was an important one. The termination clause by either party was reworded specifically to bring it into line with international best practice. There's no real change in the intent of the clause, but the wording was improved basically just to bring it in line with international best practice. The extension of time clause was improved. That was also rather loose in the old form of agreement. That was improved. And then the payment clause, and this is probably a bit of a controversial clause, but a sub-clause has been added which disallows any payment offset by the client. And I know that is an issue which has raised its head in other forms of agreement over the last several years. So that was quite an important change. And the limit of compensation by either the client or the consulting engineer to each other, by either party, in other words, That has not changed. It remains twice the amount of the remuneration paid, or in more simple terms, twice the amount of the fees applicable on the project. And then one clause which did elicit a lot of discussion, I won't say argument, it was discussion, was the dispute resolution clause, and where many other forms of agreement and other forms of contract have headed towards adjudication as the preferred means of dispute resolution. Our CISA form of agreement has stuck with, first of all, what we call amicable dispute resolution, followed by mediation, and then straight into arbitration. And I think that in itself could be a debate for another day, but it could be a debate for a whole afternoon probably. But basically, the idea was that you really should be able to resolve disputes between clients and consulting engineers in an informal, amicable manner, using either mediation or, as we call it, amicable dispute resolution processes. And if those fail, you may as well jump straight into a formal, proper arbitration situation. And I think that was actually quite a good decision. Then if you go through the document and compare it with the old model form, you will find many, many very minor editorial and small changes to various clauses, many minor wording clauses just to improve on the wording, to make it simpler to understand, easier to understand, and to correct a few errors. So there really are a number of changes, but they're small changes. Then the actual process was started, first of all, by a small group of us producing draft documents, which were then reviewed and discussed amongst us. And the final document then went to the CISA Supply Chain Management Committee, which went through quite a rigorous process of reviewing the document, checking it, asking for changes, correcting and amending. And that was a rigorous process which took time, and it was done carefully. And I think it all adds to the fact that the final product can be used and viewed with great confidence. And then obviously the specific data and the appendices, those are the sections at the back of the document, which are filled in by the client and the consulting engineer at the time that the agreement is signed. That was really updated and a lot more detail provided to make it more applicable to our current situation, and to tighten up and make sure that things that were left in the air often in the past were now highlighted and made clear. So little things that just spring to mind are aspects like proof of professional indemnity insurance, whether the client or the consulting engineer insures, and then aspects related to construction monitoring, to make it absolutely clear that both parties have a proper understanding of the level of construction monitoring required. That's been tightened up as well. So really a lot of changes have been made in the document, and hopefully all for the good. Now, moving on to the short form of agreement, we all, and I am a consulting engineer or retired consulting engineer, so I speak from experience. We all have many, many smaller appointments as consulting engineers where it's a small project, it's a small service you're providing to your client, and to fill in the model form of agreement is quite a cumbersome and time-consuming process, and it seems don't want to use the word unnecessary, but a lot of clients find it too much of an irritation. I don't know what better word to use, but so what so often happens is there's a very casual reference to the form of agreement. Nobody really knows what they're referring to, and the result is a very badly set up contract between a client and a consulting engineer. And this was why many, many years ago, CISA developed what was in those days known as the abridged conditions of appointment for consulting services, which was a much more streamlined document suitable for smaller appointments. And the last version published was in May 2011. The 2011 document, as I mentioned earlier in the presentation, it was not really based on the previous form of agreement because that had been discontinued. So the 2011 document was somewhat unaligned to the main model form, and that's the main difference in this new short form of agreement. It's really closely modeled on the main form of agreement, but it still includes all the important provisions that were in the May 2011 document. Just as a very kind of broad brush comment, it's intended for use on routine smaller projects of relatively low value, say kind of less than 5 million Rand, and of a relatively short duration, say less than 12 months. It really is ideal for specialist engineering projects, such as investigations, reports, and similar studies. It's definitely not suitable for use on any large, complex projects or multidisciplinary projects, and it's definitely not suitable for use where there are joint ventures or sub-consultants involved, simply because there's not enough detail in the document to cover the many complex situations that arise in that type of project or of that type of contracting arrangement. So there's no separate specific data section. There's the scope of services and remuneration simply reference the EXA guideline. Similarly with the time for completion. So it's intended to be a quick and easy document to complete, but it should cover everything if completed properly and used in the correct situation. Okay, so that's our short form of agreement. And then finally, we have a document which I would say is what I have a lot of pride in. I'm going to almost call it my baby. It's our baby form of agreement, the compact form of agreement. And this document arose from the realization for a need for something really, really simple and quick. So often a client phones you up and he says, oh, I just need a platform built in my factory, or I need a slab cast here, or I need to update or my electrical installation. So it's really one of those projects where you climb in your car, you drive to your client, you do the work, you haven't really got any form of agreement in place, and then something goes wrong and you've got nothing to fall back on. So we really saw a need for something that is absolutely basic and simple and quick. And that's what this compact form of agreement is all about. It's really ideal for specialist appointments like investigations, reports, and similar studies. So when your client phones up and says, I want to put a piece of plant on my floor, but I don't know if the slab will collapse, can you please come and have a look? Or I've got a crack in my roof slab, please come and have a look at it. You can use the compact form of agreement for that type of situation. It's absolutely modeled on the main form of agreement, but it only describes the essential components needed for a consulting engineering services agreement. It's literally 1.5 pages of conditions. There are just 18 simple short clauses, plus there's the signed agreement. It covers the following. It covers commencement and completion, the basic consulting engineer and client obligations. In other words, the engineer must cooperate and perform with reasonable skill, care, and diligence, while the client must assist, provide information, and pay. And I think basically that's the aim of the document. What are the parties' obligations? Consulting engineer must undertake his duties with skill, care, and diligence. The client must assist and pay. And if you get that right, your contract is pretty right. So very brief payment terms are included. Unforeseen circumstances are included, because that can happen anytime. Things can go wrong, which neither party could have foreseen or control, and you need a clause just to cover that. And then the absolute basic legal requirements, like what happens, termination only for non-payment. You see, for example, if we take that particular clause, termination, we don't make provision in this document for termination for any other reason, because it's intended, the appointment is of such a short, quick duration, there's actually no scope for termination, excepting if the client doesn't pay you, you can then terminate. So that was important. Liability is limited in both time and the quantum. And as a matter of interest, in the compact form of agreement, bearing in mind the nature of the work you'll do, it's limited, your liability is limited to 1 time your fees. PI insurance is a prerequisite. That's you must have PI insurance in place, and we define the ownership of documents and confidentiality. In other words, just the absolute bare minimum, absolutely essential components of a professional services agreement. Dispute resolution is by adjudication in this case. There's no other room for dispute resolution, except obviously you can always fall back to the courts. But there's no long process, because simply the duration of the appointment is so short that you wouldn't be able to go through a long dispute resolution process. The scope of services, the fees, and the construction monitoring construction monitoring is all simply reference to the EXA guideline. So it really is a simple, straightforward, quick and easy document to use. And I think it's going to be very, very popular amongst our members and clients, simply because it is so quick and easy to use. And with that, I think I have come to the end of my presentation, and I think I'm just about spot on my time. So back to you, Wally, and thank you very much, everybody. I hope you enjoyed it.
Thank you very much, Craig, and thank you for keeping to your time slot. And thank you, Craig, for so ably presenting on this topic and including the history and reasoning behind the revision of all the CSER forms of agreement. And I think this will be valuable for members seeking to understand and recommending the appropriate CSER form of agreement for their appointments. And we do encourage you to use the CSER forms of agreement. As previously mentioned, the presentations will shortly be available on the CSER website under guidelines/presentations/CSER forms of agreement. Just to say that CSER tries hard to empower our members with useful information through its practice notes and through webinars such as this one. Moving on, the second panelist today is Francis Gibbons, who will address us this afternoon on the CSER pre-bid agreement and the CESA joint venture form of agreement, November 2021. Francis is a professional engineer, an active member of the CESA Supply Chain Management Committee, and he is a civil engineer with extensive experience. Of note is that he was substantially involved in the recent revision or updating of the CESA practice notes, and as well as the revision of this, the subject of this session, the CESA joint venture form of agreement. So I'd like to hand over to Francis at this point. Francis, over to you. Thank you.
Thank you, Wally, and good afternoon, everyone. It's a privilege to present to you on the topic of the CESA joint venture agreement, the new one, which was published in November last year, and also on the pre-bid agreement, which was published in some time back in November 2016. So it's a bit of an older document, but the two go hand in hand. Often there's case to use one, and especially at the proposal stage, and other times to use the other. Okay. So the purpose of the joint venture agreement, it's intended to formalize agreements between professional service providers who are going to be engaged in securing appointments and performing professional services relating to construction projects. Or in fact, it can be not necessarily a construction project, can be anything: feasibility studies, water resources studies, etc. So it can also be used to govern the JV at the proposal stage of the project, but the agreement can only really be finalized at the end of the proposal stage when the split of work and fees is known. On the other hand, the pre-bid agreement can be signed at the start of the proposal stage, even before the proposals come out. It's when consultants are jockeying for teams and setting up their teams for a particular project. It's good to have a pre-bid agreement that can be signed at that stage. However, it's good to know that sometimes the client will require a JV agreement to be submitted with the proposal. So you might need to have it signed up before you submit the proposal. Okay, I just wanted to talk about this, something that's caused me a lot of confusion over the years. The difference between an unincorporated and an incorporated joint venture. But first, the definitions from the form of agreement, from the JV agreement. So a joint venture means the entity formed by formal agreement by the members for the sole purpose of securing an appointment by the client and to perform the services set out in the PS agreement and any further services which might be agreed to by the members. The agreement itself, the joint venture agreement, means the agreement between the members of the joint venture to form an unincorporated joint venture. So here we come across the term unincorporated joint venture, which I'll touch on in the next slide. The other important definitions from clause 1 is the specified proportions, which are the respective financial interest of each member in the joint venture, as stated in the specific provisions. So what's the difference? And in an incorporated JV, the parties agreed to create a new entity by both contributing equity, and they then share in the revenues, expenses, and control of the enterprise. So it's a separate company. In an unincorporated JV, on the other hand, each participant retains a separate legal status, and the JV's control over each participant is generally limited to activities involving the joint endeavor, particularly in the division of profits. The JV is formed by contract, which is the JV agreement, and that delineates the rights and obligations of each member. So another term you'll also see quite often is a consortium, and it doesn't really have any legal definition. There are no such things as consortium agreements, and it's generally taken to mean an unincorporated JV. So I'm going to go through and touch on other few clauses in the JV agreement that I think are interesting and of importance. So the first one is clause 3, exclusivity. In the JV agreement, this covers the exclusivity of the members during the performance of the services. So it says no member shall be associated in any manner, either directly or indirectly, with any activity relating to the performance of the services, including any additional omission from the scope of service, except as a member of this joint venture. In other words, you can only deal with this project as a member of the JV. So that's fine, but clause 11 of the pre-bid agreement covers the exclusivity at RFP stage. So and that's something you need to have, because there have been cases in the past where JVs have been eliminated from tender evaluation process because one of their members was in more than one bid, and then both the JV firms were eliminated. So it's good to have a signed up exclusivity at RFP stage, and that's something that the pre-bid agreement has, and it's good to add into your JV agreement. Okay, in profits and losses, clause 5, the profits and losses, liabilities and assets of the joint venture shall be borne by the members in accordance with the specified proportions as described in the specific provision. Sorry, it's quite easy to get mixed up between these two. So on the other hand, in clause 3 of the pre-bid agreement, the nominal equity share of the parties can be defined to be finalized at agreement stage. So you might have a case where the parties agree to a 50-50 joint venture, or there's 3 parties and it's a 1/3, 1/3, 1/3 split. And it's important to obviously to state that in the JV agreement what is envisaged with regards to these proportions. Because there's 2 common ways, in my experience, that work is split between the members. The one is you might conduct the affairs of the JV as an integrated team. So the parties, the members second team members into a project team, which might be in a separate project office, and then the team works as a single team. So it might be you have a structural engineer from one firm and a water engineer from another, and a modeler, a BIM modeler from another firm. So the team is really made up of people from the different JV members. And the way to govern that then in terms of the specified proportions is that you strive to manage the input from each member, or the number of staff allocated, or the value of the staff allocated to the JV in proportion to their specified proportions. And then the profits and losses can be then shared in accordance with the specified proportion. You might in some cases want to split it with in relation to the actual participation of the members, which in the end might be slightly different to what the specified proportions are, or you might just say no, we're going to split it on the in relation to the specified proportions. And I prefer the latter, where you're just going to split profits in accordance with the specified proportions, because it keeps everyone in line and striving to maintain that equal, or however it is, number of staff, equal participation in the joint venture. The second way that the JV might operate is when the work is split on the basis of discipline or work packages. So work packages given to a particular firm, and then the team is not integrated. And then the split needs to be made on the basis of the amount of work that's given to each member. Okay, so that's about the specified proportions. We'll see some of that later on again. Then clause 6 deals with pre-award costs. So generally, in both the JV agreement and the pre-bid agreement, each party will carry their own costs incurred in supporting the RFP submission. However, there is provision in the appendix to the JV agreement for the members to specify certain costs that might be shared between them at prior to award. For example, in obtaining a BEE certificate for the JV. Okay, how does the JV operate? That's covered by clause 7. There's a management committee. It comprises one representative from each member with authority to bind the member within the terms of the JV agreement in all JV matters. The chairperson rotates on a 6-monthly basis. Decisions have to be unanimous, and if not unanimous, the matter is adjourned for 48 hours. And if in the reconvened meeting the decision is not unanimous, the decision is taken by a majority vote, in which case the chairperson has a casting vote. If the dissenting member disagrees with the decision, then he may refer that to dispute. So the one thing to note about the CSER JV agreement is it does not define a lead member. So there's no concept of a lead member in the CSER JV agreement. So the chairperson rotates on a 6-monthly basis. And this is okay, except for the fact that the chairperson has a casting vote in cases where a decision is not unanimous. And this may be an issue where the shareholding defined in the specified proportions is not equal. If one party is a 60% shareholder and the other only a 40%, then it would not be fair for the chairperson to have a casting vote on behalf of the minority shareholder. So in that case, this clause can be amended in the specific provisions. The operation of the MANCO, what is its responsibilities? The MANCO appoints the project leader and dictates overall policy to the project leader regarding the general day-to-day management of the JV, how he represents the JV, coordinating the activities of the JV, etc. They also approve the proposal to be submitted for the services, approve the accounts of the JV, determine the nature and extent of additional duties and functions to be formed by the members, determine the terms and conditions of employment of staff and remuneration of persons seconded by the members, determine the requirements for and procure all other resources required, e.g. if you're going to set up a project office, the premises, the furniture, the office equipment, etc. Determines and approves any working capital requirements, borrowings, etc. to be taken out by the JV, or requiring that the JV members leave parts of their income in the JV accounts, and approve sub-consultants. So this brings up another topic that is frequently an issue, is staffing of the JV. So generally, a JV, an unincorporated JV, does not have any employees. And the main reason for this is to avoid that the JV has to register for PAYE and the various HR and admin businesses that go along with that. So persons can be appointed to the staff of the JV, but then they will be seconded from one of the member firms. For example, you might second the project leader and the finance and admin manager. So they would continue to be employed by one of the member firms and seconded to the JV. Even if you bring someone in from outside, best is to employ them in one of the member firms and then second them to the JV. The JV can, of course, appoint sub-consultants directly. It is an entity, so it can enter into subcontract agreements. So that is another avenue to employ a staff on a purely a subcontract basis. Another important thing of running a good JV is to have good accounts prepared. So this is covered in clause 10. The JV shall cause proper books of account and complete records according to good accounting practice. The project leader, assisted by the finance and admin manager, shall prepare quarterly management reports for approval by Manco, and the final accounts shall be prepared and audited on completion of the services from which the final profit and loss sustained by the JV can be ascertained and distributed. So obviously on smaller projects, perhaps this is not done to the same extent that it's done on big projects, but certainly on big projects, you need to have your books being kept up to date and reported to the Manco on a regular basis, so that so it's all open and fair. Okay, other important thing is liability. Of course, in most cases, the JV will be held jointly and severally liable by the client. But there is a clause now in the agreement that each member then indemnifies the other members against all legal liabilities arising out of the performance or otherwise of its obligation. In other words, that member's obligations under the JV agreement. So if one JV member has a claim against, gives rise to a claim against the JV, then that member will indemnify the other members against the legal liabilities arising out of the performance. And it would mean that although the JV might have a claim against it jointly and severally, at some stage that the member who was at fault will need to reimburse the JV and the other members. Of course, in the case where a claim arises, then JV is not, not through the default of any member, but perhaps when you've got an integrated team, so it's something the JV does as a team, but it's directed at one of the members under the joint and several liability provision, maybe the biggest member, maybe the one with the biggest PI cover. The other members undertake to compensate that member. So those are the terms covering liability. Of course, there's also issues with PI insurance in JV. Sometimes the client is happy with each joint venture member having a certain amount of PI cover, a minimum amount of PI cover, and in other cases they want to have the JV take out specific project-specific PI insurance to cover the liability. Then the IP rights. So under the joint venture agreement, the ownership of data, design knowledge, and intellectual property rights in the designs, documents, and drawings produced by the members in performing the service shall remain with the member concerned. The other members can only use such data, design knowledge, and intellectual property rights in the performance of the services and not for any other purposes whatsoever. So this clause is perhaps more applicable when the services are split between the members on a disciplined basis. In cases where the JV functions as an integrated team, the ownership of the IP is then held by the JV, and members should request permission from the JV to use the IP outside the project. So the JV is holding the IP for work produced on an integrated team basis. Okay, then as Craig was mentioning, some of the agreements make provision for adjudication, and the JV agreement does. So it makes provision for adjudication after the amicable settlement process has failed. However, there's no rules set out for adjudication in the CESA documents, and I think that's something we'll add in future copies, in future versions rather. So at the moment, where agreement cannot be reached on the rules of adjudication, you can get direction from the president of CESA. However, as I say there, it is recommended that the rules be set out in the specific provisions. Okay, well, that's an overview of the JV, new JV agreement from CESA. and I'm sure it's going to find a lot of applicability in amongst CESA members. So good luck and go forth. And over to you, Wally.
Thank you, Francis, for that excellent presentation, which will greatly assist members in understanding the intricacies of the CESA joint venture agreement and also assist them in understanding how to apply it. And just to remind everyone that the presentations and the recording of the webinar will be available on the CESA website. The final panelist this afternoon will be Charles Salia, who will speak on the CESA Model Subconsultancy Agreement, October 2021. Charles is a professional civil engineer and a technical director at the member firm Jones and Wagner, and he is an active member of the CESA Quality Risk and Sustainability Committee. Charles is the current president of GIGSA, or GIGSA, which stands for the Geosynthetics Interest Group of South Africa. Of note is that he was significantly involved in the recent development of the CESA Management System Declarations, which are also known as the MSDs, as well as the revision of the CESA Practice Notes. And at this point, I'd like to hand over to you, Charles. Over to you.
Hi, thanks for that very kind introduction, Wally. So today I'm going to be talking about the Model Subconsultancy Agreement and specific data, which was finalized last year in October. This is essentially what the hard copy document looks like. And as been discussed already, it forms part of a suite of 5 documents. What I'm going to do is just run through the contents of my rather short presentation. There's been a lot of content that's been discussed before, which is applicable to this document as well. And I'll just go through briefly the similar sections of this document as compared to the main form of agreement. And then I will just talk about how to access the forms in general, and then also just end off discussing the copyright of these documents, and then draw some conclusions. So just as a part of an introduction, as Craig alluded to, there was a previous version of this document, which was drafted in September 2014. This is an all-new version. The previous version was not based on the model form of agreement, so it was fairly different to the main form of agreement between the consultant and the client. So the new approach is to base it on the same model, so you'll see it's a very similar document. The main model includes main elements such as the scope, the fees, the schedule, the liability, and dispute resolution, as discussed in quite a bit of detail by Craig. And CESA's view is this is recommended to other alternatives or forms of agreement, such as the FIDIC form of subconsultancy agreement. So the reason of using a form of agreement is really just to make sure that the risk of each party is balanced and limited. You know, if you use a document which has been drafted by a consultant and is not a general form, the risk can be skewed and will usually be skewed in the direction of the person who hasn't drafted the document. So it's really suggested that this document be used to balance the risk. So let's just go through the general sections of the agreement. Just starting on the diagram on the left, at the top, number 1, definitions. As Craig discussed, you know, these are just the definitions that are used in the document. It is a very straightforward document. You know, the legal terms are kept to a minimum. Section 2 and 3 are the obligations of the parties, being the subconsultant and the consultant. Section 4, the duration of the services. Section 5, remuneration, how the subconsultant is going to be paid. Section 6, liability and insurance. Section 7, general provisions. Section 8, how disputes are going to be resolved. and section 9, the specific data and appendices. But let's just look at those appendices in a little bit more detail. So section A1 is the appendix, which discusses the scope of services in detail, and is project specific. Section A2, or the appendix A2 is the remuneration and would include the project specific payment terms. Section 3, the time for completion, essentially the sub-consultant schedule. Section 4, the client consultant agreement. So this would obviously form part of agreement that is between the client and the consultant that would be appointing the sub-consultant. And the important fact here is that the full agreement doesn't have to be contained in the contract, but only the specific clauses and terms which are specific or relevant to the sub-consultant. But just keep in mind that any terms and clauses that aren't included obviously would not then be something that you can hold the sub-consultant to. And then lastly, Appendix A5 is the documents appended. This could be the client's safety specific requirements or environmental specific requirements, or any other documents which are relevant. Some highlights. So these were some important clauses that I picked up while going through the document. There's a little bit of overlap here between what Craig has said, but it will just enhance the points a bit more. Section 4.4, the force majeure clause, provides a way forward after unexpected circumstances, such as a national declared pandemic. Section 5.2, the set-off clause being excluded. Section 6.3, duration of liability, and section 6.4, limits of compensation in terms of liability. So these are really important to make sure that the liability isn't open-ended between the two parties. Section 6.5, the insurance for liability and indemnity. So it's really important that the sub-consultant has sufficient PI insurance to cover their liability, and that will very much limit the risk of both parties. And then section 7.9, variations. It's really important to have such a clause to manage change management throughout the project. And lastly, section 8, settlement of disputes. As stated by Craig, it's a tiered resolution process, but they haven't included the step of adjudication. And the motivation being that, you know, if one of the earlier processes do not work, it's a rather large step up to arbitration, and this might be a motivating factor to try and settle or mediate the dispute. So that's essentially the contract. I'm just going to touch on where to find all these forms of agreements, but with the focus on the one that I'm talking about. So if you head to the CESA website and scroll down, you'll find the bookshop, and you can enter through this link. This will take you to where the contract documents are for sale. So from here, we split to two options. Either you can order online, or you can scroll through the various documents that are available, and you can get more information on those documents, as well as the contact details for ordering from CESA a hard copy of the contract. But if you'd like to order online a soft copy, you can click here to begin. It'll take you to this form where you fill out the various information that's required, and this is going to pre-populate the contract documents in a PDF form for you. You'll see right at the end there's the type of contracts that you wish to create, just before confirming that you're not a robot. And then there's also an option there to click and view a sample, and that's a really handy feature to see what sort of documents you're going to be receiving. So if you'd like to order a hard copy, you go back through the list and you find the one that you like. Make sure that you're looking at the October 2021 version if you want the latest model format. The earlier 2014 format is still available on the website, or through order from CESA. I just wanted to point out the quite low cost of these documents. And this becomes important when one considers the copyrights, which is what I'll go through next. So just before I do that, these are the ordering details that you need to use in order to order hard copies. So you'd contact Patience at CSER, and she would be able to assist you with that. Let's just look at the copyright for a second. So all these forms of agreements are copyright by CSER. The documents are intended for single use only. The soft copies that are purchased online are pre-filled in per project. You know, that form you filled in, those points are carried across. And the point being that the idea is that you would purchase a contract for every project that you use, or if you're on a project and you're using various sub-consultants, in this specific case, you would order one contract per sub-consultant. So that's the view behind keeping these documents at quite a low cost. So then just in conclusion of the sub-consultant agreement, it is a completely new version compared to the 2014 version. It does have all the essential elements required for a general form of agreement. It does balance and limit the risk of both parties. And yeah, you can either get them in soft copy or in hard copy, but just note the copyright licenses. So yeah, that was quick and short, but it is very much similar documents to the general form of agreement. And yeah, Wally, I think I'll be handing back over to you.
Thank you very much, Charles. That was an interesting presentation, and it provided useful guidelines for members on the purpose and the use of the model sub-consultancy agreement. Also, thank you very much for outlining the route to purchasing these agreements, as well as the rules outlining intellectual property requirements and so forth, which is important information for any members or anyone purchasing standard contract documents from the bookstore. So thank you very, very much for that input. At this stage in the proceedings, I'd like to pose the questions submitted by the delegates to the panelists for their response. So here goes. The first question, and forgive the pronunciation, is from Andy McClarty. And he says, I think this is for Craig. Has the client indemnity of consultant against third-party claims, which is greater than the agreed limit of liability, been retained in the 2021 form of agreement? It has been removed from the FIDIC 2017 and is often pushed back by the clients, particularly parastatals, because in terms of Section 66 of the PFMA, they cannot provide indemnities. So Craig, can you try and answer that, please?
I can answer it very quickly. The simple answer is yes, it's still there. It's clause 6.6, and it answers that query exactly. So the indemnification by the client is still there.
Okay. Thank you very much, Craig. I think the difficulty of the question that I sort of imposed on the question was actually my own lack of understanding. So sorry about that.
No, well, I can tell you that I saw the question in the box and in the Q&A box, and I cheated. I looked it up quickly, so I was able to answer it when you called on me. Thanks. Okay.
Well, thank you very much. All the same. Then the next question is from Nati Mogane. Is it, and I think it's directed at Francis, is it an automatic requirement to have a joint BEE certificate when entities enter into a JV agreement, or is this a client or proposal specific requirement? So Francis, can you answer?
Okay, thanks, Wally. I think it's a proposal specific requirement because it's often when the JV is being given its preference score that they'll use the joint BEE certificate to allocate the score. So, you know, if you were bidding on, for example, to a private client who didn't use the 90-10, then you wouldn't need the joint BEE certificate. I think that's, yeah, I don't know where, Craig, if you've got anything to add, or Wally.
No.
No, I've got nothing to add to that. I think you're correct, Francis. I would agree with what you've said. Yeah.
Okay. Thank you both very much for answering that. Then we have one from Nkululeko Mieza, who says, can a pre-bid agreement be used during an RFQ in which consultants bidding jointly with a contractor, for example, for a turnkey application, turnkey appointment? And that's for Francis, I think.
Thanks, Wally. That's a very interesting question. So, of course, a pre-bid agreement can be used in any instance, but just bearing in mind that it's really set up for collaboration between consulting engineering firms, it does deal with things like joint and several liability. And I can read you the term from the pre-bid agreement. It says all partners of the consortium or JV are liable jointly and severally for the execution of the contract. So I would think that you really don't want to be in a joint and several liability JV with a contractor. So you would need to put in specific clauses. So I think the JV, the pre-bid agreement as it stands is probably not the right agreement to use for when you're going in with a contractor.
Okay.
Thanks, Wally.
Thank you very much, Francis. Then just to make sure that Charles is not left out of the firing line, can the CESA sub-consultancy form of agreement be used with any main form of agreement used by the main consulting firm, or is it best suited to be used alongside the CESA model form of agreement, the main agreement?
I would say that if you had the choice, it would be better to use CESA forms of agreements for both agreements, because then they're essentially back-to-back agreements, which have very similar terms and conditions. In the scenario where you have a different form of agreement between the client and the consultant, and that form of agreement doesn't have its own sub-consultancy form, then I would recommend this in compared to other forms of agreements, simply because it is set for South African conditions, and it does limit the liability and balance the risk. So in absence, I would recommend this. But yeah, if it's a FIDIC main form and FIDIC has a sub-consultancy agreement, it would be better to use that, because then the forms are very similar, and they would be essentially back-to-back agreements.
Thank you very much, Charles. That's great. We seem to be flooded, well, relatively speaking, with questions now. We have one from Vincent Knox, who says we are being approached for turnkey agreements where clients wish the consultant to be lead and have the contractor under the consultants. Typically, this would need a professional services section and a contracting section. Is this being considered? And maybe I can direct that to Craig, being the primary author of forms of agreement. Craig?
I really can't answer that, I'm afraid. I'm not aware of any talk of looking at such an agreement. It's a very, very specialized situation. I'm not aware that any of the organizations have a document specifically for that application. I don't think FIDIC have one. I think the FIDIC documents are more suited to the situation where the contractor is the lead. So it's design and construct, but those arrangements are normally where the contractor is the lead body in the arrangement. So no, I'm not aware of anything. I'd be very, very cautious about a consulting engineer taking on the lead role in a project, because in a construction project, because the consultant is then taking on the risk for the entire constructed project. So the risk is enormous.
Yes. Well, thank you very much, Craig. I think you've done an excellent job in answering that and pointed out some of the pitfalls, and I can see why it's not being envisaged, because it seems the disadvantages outweigh the advantages. The next question, which is, I think, for Francis, it's from Alan Liversage. With respect to the JV agreement, I may have missed it, but does it deal with the invoicing party, relative to the other JV parties and bank accounts? This is to facilitate practical ease of invoicing and banking by the JV. Francis?
Thanks, Wally. Yeah, I didn't cover it in the presentation, so you didn't miss it, Alan. But there is a clause 11.1, working capital and bank accounts, which says banking accounts shall be opened in the name of the joint venture at a recognized banking institution as may be determined by the ManCo. So that is specified in the joint venture agreement. It's sometimes my experience with smaller JVs or smaller projects that's not done, and one of the members opens a JV bank account, or opens an account in the name of the JV under their account, if you like. With regard to the invoicing procedure, that's also covered under 11.4. The ManCo shall determine the invoicing procedure to be adopted in respect of the members invoicing to the joint venture, which shall complement the procedure for the joint venture invoicing to the client. So both those are, yes, covered under clause 11 of the JV agreement.
Oh, thank you very much, Francis. Great answer. And then we have an anonymous attendee asking, does CESA have a specific agreement to cater for consultants in a turnkey project with a contractor? And I'd ask Craig to answer that, please. Craig?
Well, I once again would really rely on my colleagues for comment on this, because I think the simple answer is that CESA does not have a specific agreement. I think as a very general comment, without knowing the details of the particular situation, there's no real reason why you shouldn't use the standard, if I can call it that, the model form of agreement in a situation like that. But that is a field that is somewhat out of my expertise. So maybe Francis or Charles can answer that better. Yeah, okay. I think, Craig, I agree with you as well, that normally if in a situation like this, the contractor becomes your client, and so you set up a client consultant agreement with the contractor. The real issue in those situations is the risk sharing, and yes, one has to be extraordinarily careful about the risk that you're taking on in that situation, which goes back to the previous question as well. But yeah, as Francis says, I think normally the standard form of agreement is usable. Charles, you might want to comment as well.
I would just like to say that I agree with both of you, and I would, as an additional step, probably arrange for a legal review of the contract before signing it. Yeah.
Okay, I think thanks to the panelists for their answers. And I'd also like to thank the audience for putting forward some very good questions and challenging the panelists to dig deep and find the answers. So thank you everybody for that. So we've come to the end of the question and answer session, and I hope all the questions have been addressed. However, I would like to inform you that you're welcome to email me at wally@cisa.co.za regarding any questions or any help you may still want or have that were not answered during the webinar, and I will see that they are answered. Colleagues and friends of CISA, we've reached the end of the webinar, and I'd like to thank the panelists for availing of their time and for sharing their knowledge and thoughts with us. And of course, a big thank you to you, our delegates and viewers, for supporting CISA and attending our Forms of Agreement webinar. Before we close our session, we'd like to invite you to submit any comments or suggestions you may have regarding our best practice webinars, with a view to improving them and making them more useful. You are welcome to suggest topics that you would like addressed at future webinars. And again, you may send me these comments and suggestions to wally@cisa.co.za. In closing, I would like to kindly request delegates to complete the satisfaction survey. It will pop up on your screen when you exit the webinar. The purpose of the survey is to provide us with your satisfaction ratings or feedback that will enable us to improve our future webinars. Just to remind you, delegates registered with EXA may claim 0.15 CPD points for attending this webinar, and we'll send you these certificates according to our attendance list. And we'll do that once you've completed your survey. So there's an incentive there to complete your satisfaction survey. As a very last point, we'd like to ask members to regularly check their spam or junk folders in the email for CISA correspondence in case it has ended up there. We'd also like to request that you whitelist the email addresses that CISA uses. And with that, thank you again for your attendance and participation. And I'd like to wish you a good day further. And goodbye.
Thank you. Bye-bye.
Bye. Ciao.